davayı takip ediyor ve yine Filistin'e destek gösterirsen insanlar böyle sağlığı önemli karar bir haftada Cumhuriyeti Uluslararası Adalet Divanı'nın İsrail soykırım yaptığı suçlamasıyla başvurmuştu ve geride bıraktığı ilan yönetmenin duruşma Türkiye'den de milletvekili dünyanın görüşlerinin konusuyla Güney Afrika Cumhuriyeti'nin siyaseti kararları çerçevesinde 9 madde ateşkes sağlanması, insanların güvenlikleri evlenilmesi ve özellikle böyle soykırıma karışan yargılanması aynı zamanda bir davadan bahsediyoruz. Saatler gösterdiğinde yaklaşık burada karara açıklayacak. Tedbir kararlarına baktığımızda aslında buradan şu kararların çıkabilmesi muhtemel olduğunu düşünüyoruz. Özellikle soykırımı önleyecek tedbirlerin alınmasını talep edebilir mahkeme ve sivillerin zayiattan kaçınılması, insani yardımların acilen ulaştırılması, soykırım ölümlerin muhafaza edilmesi toplamak üzere Gaze'ye giriş yapacak Birleşmiş Milletler verilen yetkilerin engellenmemesi gibi hususlar var. İşte bu hususlara ilgili yaklaşık 50 dakika sonra o önemli karar açıklanacak. Bahsettiğimiz gibi hayli önemli bir karar, ihtiyati tedbir kararları ve dünyanın gözünün çevrildiği bu noktada burada Filistin'e destek amaçlı göstericiler ve süreci bekliyorlar. Güzel bir telefon Türkleri olarak gelişmeleri anlayan aktarmayı sürdürüyoruz. Tam çocuk aradın Yasin ya. Tamam önemli değil. Eyvallah. Anadolu Ajansı da değil abi şey. Sitesinden geliyor. Ajansı da.
المرجح إلا أن السيناريوهات الأخرى أيضا وإن كانت بعيدة أو ضحية الحدود إلا أنها أيضا يمكن أن تحكم المحكمة بعدم الاختصاص وإسقاط الدعوة كما كانت قد طلبته إسرائيل. أيضا احتمال بأن تأخذ إجراءات جزئية بمعنى أن بعض المطالبات لعدم اللاجئين وإرسال مساعدات دون الأمر بوقف إطلاق النار. ترقب كبير ريبي من سواء الجالية الفلسطينية أو كل العالم خاصة
اليوم يوم تاريخي بالنسبة للقضية الفلسطينية، يوم تاريخي بالنسبة لإنصاف الحقوق والإنصاف الإنساني على مستوى العالم أجمع. اليوم حقيقة ينبغي أن يصدر قرار مباشر يطالب هذا الاحتلال بوقف الاعتداء وعلى قطاع غزة ووقف الحرب والقصف على غزة ووقف قطاع غزة. هذا ايضا القضيه تصدر عن المحكمه. ايضا نرجو ان تكون هناك اجراءات حقيقيه تمنع اي حال او اجراء تقوم بها الاحتلال الاسرائيلي بحيث يعزز هذه العمليات العسكريه التي يدخل فيها في داخل قطاع غزه. والامر الاخر ان يكون هناك يسمح المساعدات والانسانيه والاغاثيه من المنظمات الدوليه الى ان في داخل المنطقة. أما بالنسبة لدرجة التفاؤل والتوقعات نتمنى أن تتمتع القرار اليوم بالشفافية والنزاهة الكاملة. اليوم الأمر لا يحتاج إلى جد واختصاص بالموضوع حتى يفتي أحدهم بأن غزة وجريمة الحرب، والأمر واضح بالنسبة للحقوقيين قبل عموم الناس، وبالتالي اليوم ينبغي أن يكون هذا القرار مع هذا الأمر. لكن أتمنى أن لا نفاجأ اليوم قرار هزيل يتم فيه نشر فيه ونلتمس فيه دخول عصا السياسة والأيدي السياسية في داخل القرار واللعب فيه. هذا ما نتمناه في الجالية الفلسطينية في هولندا، ويتمناه كل شعب الفلسطيني وخاصة المصابين والمكتومين في داخل غزة. يعني هذا الدور الذي يمارسه اسرائيل اليوم هو دور تعودنا عليه كثيرا. اسرائيل تحاول في كل وقت من الاوقات تزييف الروايه، اللعب على الروايه الكاذبه والمكذوبه، تشويه الحقائق، وهذا مستمر منذ سنوات ولم يختلف كثيرا في هذه المرحله وفي هذا المكان. اليوم صراحه المحكمه امام تحدي حقيقي كبير. اليوم هي الهيئه القضائيه العليا على مستوى الامم المتحده ككل، وبالتالي المرجو ان لا تتاثر بشكل مباشر بالبروباغندا الاسرائيليه التي تحاول التاثير وتحاول تخطيط الحقائق وتحاول البناء حقيقه على هذا الوجه الاجرامي الدموي الذي يمارسه غزه. فنرجو ان لا يؤثر هذا الملف بشيء، وهو لا يتعدى كونه محاوله من المحاولات التي يحاول فيها الاحتلال الاسرائيلي التغطيه على جرائمه وخلق مبررات غير قانونيه وغير صحيحه وغير انسانيه هي ما يقوم به بالاباده الجماعيه في داخل غزه. يعني حقيقة الدعم الأمريكي غير محدود لإسرائيل هو مستمر. من يراهن على تغيير موقف الأمريكي تجاه الدعم لإسرائيل هو مراهنة خاسرة وغير صحيحة. إسرائيل هي الفتى المدلل والطفل المدلل في الولايات المتحدة الأمريكية في المنطقة، وهي تنفذ مصالحها. إسرائيل تحمي تنفذ مصالح الأمريكية وأمريكا تحمي إسرائيل في داخل المنطقة، وبالتالي لا نعول كثيرا على تغيير في هذا الموضوع، لكن نقول أن اليوم هو قد يكون يوم تاريخي إذا صدر قرار إيجابي من المحكمة العدل الدولية اليوم. أعتقد أن الولايات المتحدة ستجد نفسها هذه المرة أمام السلطة القضائية الأعلى في العالم، ولا تجد نفسها فقط أمام هيئة تنفيذية أو حقوق حقل الفيتو أو مشروع مقدم من إحدى الدول هنا أو هناك. لا، اليوم قضاء العالم السلطة القضائية في العالم ككل تصدر هذا القرار، ونتمنى أن يصدر القرار بشكل كبير، وبالتالي هذا سيحرج أمريكا بشكل كبير لأنها تقوم بمواجهة هذه السلطات. وهذا صراحة إذا كانت مواجهة بشكل مباشر وطعن ومخالفة مباشر هذا يضعنا أمام حقيقة الشكوك صريحة وواضحة أمام مصداقية هذه الهيئات الدولية إذا كان سيتم التلاعب فيها وتلعب بقراراتها من خلال هذه الدولة.
Viva, viva Palestina! From the river to the sea, Palestine will be free! Palestine will be free! عاشت فلسطين حرة من البحر للنهر! Free, free Palestine! Boycott Israel! Israel has to disapprove! نتنياهو كان سكالر يا عمو! Boycott Israel! Free, free Palestine! Viva, viva Palestina! Boycott Israel! From the river to the sea, Palestine will be free! Palestine will be free! Viva, viva Palestina! Boycott Israel!
The unanimous vote of the General
Israel
Assembly on this
criminal!
matter in
Israel
itself
assassin!
reflected the
Disapprove of
determination
Palestine!
of the peoples of the United Nations,
Israel criminal!
whatever their race, creed, or
نتنياهو
nationality,
criminal!
to assure
صوروا
the
صحافة!
progress which had so
Boycott
recently shocked
Israel!
the countries of mankind
نتنياهو كان
would never
سكالر!
again take place.
Hey, Yunus, apartment on Israel! Netanyahu can
Kentucky.
Kentucky, wow.
I'm working on the Associated Press for this one.
I was born in New Zealand. I married a Dutch lady after the army, and she brought me here.
Oh, she brought you here. Came here for the food and the weather, yeah. Each time each day when I moved here, I was like, yep, came here for that. Makes me feel alive. Yeah.
יריב, אנחנו עכשיו בטלוויזיה.
אין צ'אנס, אין צ'אנס. אני מכוער מדי. Shaka, this guy came all the way from Kentucky to take
Kentucky.
No way.
Yeah, there's fried chicken there. And bourbon.
the best in the world. I love fried chicken.
Yeah.
Good.
I mean, I feel like some taste have better chicken than that. We have more market appeal.
You came especially to cover this story?
Oh no, I live in Amsterdam.
There'll be enough space for everyone to get the shotgun coming in. Good.
Please guys, if we can make space.
Sure, yeah.
He's going outside. Okay, I think everyone's here. We can proceed.
Princeton.
Where are you going to sit there? Because I want to sit there.
You should sit at the end.
Ah, ça va bien.
We'll need at least 2, 3, 4.
But there's the minister and the agent.
And we can always move if necessary. Nice to see you after all these years. How many Israelis here? We must move down there.
He's told me.
You're disgracing.
So you
No, they move on.
Yes.
How could you?
And now I'm not sitting behind him.
Oh dear.
No, that's all.
And you made it all happen.
No, but I'm looking after him.
Okay. You sure?
Yes.
It's your right. Is it your right? When did you get here? Yesterday. How can you get
Choice.
here we are.
יש עוד מישהו חוץ מיו"ש שאתה רוצה להגיד? לא? אתה מבין? תסתכל, זה מה מצוין.
That's the one that deals with individuals. Remember, there's a case out, an arrest warrant out for Vladimir Putin with regard to the war in Ukraine from the International Criminal Court. I think it's interesting if this court still a bit.
You gentlemen have to interrupt me because the judges have just taken the seat. We're going to take you to inside the International Court of Justice in The Hague, where the judges are about to read out their preliminary verdict over this case by South Africa. Let's listen.
In punishment of the crime of genocide in the Gaza Strip, South Africa versus Israel. Judge Robinson, who duly participated in both the deliberation and the final vote, is, for reasons made known to me, unable to take his seat on the bench today. I would like to welcome the eminent representatives of the Republic of South Africa and the State of Israel who are in the Great Hall of Justice today. In particular, I recognize the presence of Her Excellency, Ms. Naledi Pandor, Minister of International Relations and Cooperation of the Republic of South Africa. I recall that on 29 December 2023, South Africa filed in the registry of the court an application instituting proceedings against Israel concerning alleged violations in the Gaza Strip of obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention or the Convention. The application of South Africa contained a request in which the present case came before it. It observes that on 7 October 2023, Hamas and other armed groups present in the Gaza Strip carried out an attack in Israel, killing more than 1,200 persons, injuring thousands, and abducting some 240 people, many of whom continue to be held hostage. 240 people, many of whom continue to be held hostage. Following this attack, Israel launched a large-scale military operation in Gaza by land, air, and sea, which is causing massive civilian casualties, extensive destruction of civilian infrastructure, and the displacement of the overwhelming majority of the population in Gaza. The court is acutely aware of the extent of the human tragedy that is unfolding in the region and is deeply concerned about the continuing loss of life and human suffering. The ongoing conflict in Gaza has been addressed in the framework of several organs and specialized agencies of the United Nations. In particular, reservations have been adopted by the General Assembly and the Security Council of the United Nations, referring to many aspects of the conflict. The scope of the present case submitted to the court, however, is limited, as South Africa has instituted these proceedings under the Genocide Convention. The court then turns to the conditions needed to be fulfilled in order for it to indicate provisional measures. With respect to the question of prima facie jurisdiction, the court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, South Africa seeks to found the jurisdiction of the court on Article 36, Paragraph 1 of the Statute of the Court and on Article 9 of the Genocide Convention. The court must therefore first determine whether those provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Article 9 of the Genocide Convention provides, I quote,
disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. South Africa and Israel are both parties to the Genocide Convention, and neither of them has entered a reservation to Article 9 or any other provision of the Convention. The Court then recalls that Article 9 of the Genocide Convention makes its jurisdiction conditional on the existence of a dispute relating to the interpretation, application, or fulfillment of the Convention. A dispute is a disagreement on a point of law or fact, a conflict of legal views or of interests between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. To determine whether a dispute exists in the present case, the Court cannot limit itself to noting that one of the parties maintains the Convention applies while the other denies it. Since South Africa has invoked as a basis for the Court's jurisdiction the compromissory clause of the Genocide Convention, the Court must also ascertain at the present stage of the proceedings whether it appears that the acts and omissions complained of by the applicant are capable of falling within the scope of that convention, ratio materiae. The Court recalls that for purposes of deciding whether a dispute existed between the parties at the time of the filing of the application, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, it pays special attention to the author of the statement or document, its intended or actual addressee, and its content. The existence of a dispute is a matter for objective determination by the Court. It is a matter of substance, not a question of form or procedure. The Court notes that South Africa issued public statements in various multilateral and bilateral settings in which it expressed its view that, in light of the nature, scope, and extent of Israel's military operations in Gaza, Israel's actions amounted to violations of its obligations under the Genocide Convention. For instance, at the resumed 10th Emergency Special Session of the United Nations General Assembly on 12 December 2023, at which Israel was represented, the South African representative to the United Nations stated that, I quote, "The events of the past 6 weeks in Gaza have illustrated that Israel is acting contrary to its obligations in terms of the Genocide Convention." End of quote. South Africa recalled this statement in its note verbal of 21 December 2023 to the Embassy of Israel in Pretoria. The Court notes that Israel dismissed any accusation of genocide in the context of the conflict in Gaza in a document published by the Israeli Ministry of Foreign Affairs on 6 December 2023, which was subsequently updated and reproduced on the website of the Israel Defense Forces on 15 December 2023 under the title, "The War Against Hamas, Answering Your Most Pressing Questions," stating that, I quote, "The accusation of genocide against Israel is not only wholly unfounded as a matter of fact and law, it is morally repugnant." End of quote. In the document, Israel also stated that, I quote, "The accusation of genocide is not just legally and factually incoherent, it is obscene, and that there was no valid basis in fact or law for the outrageous charge of genocide." End of quote. In light of the foregoing, the Court considers that the parties appear to hold clearly opposite views as to whether certain acts or omissions allegedly committed by Israel in Gaza amount to violations by the latter of its obligations under the Genocide Convention. The Court finds that the aforementioned elements are sufficient at this stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. As to whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention, the Court recalls that South Africa considers Israel to be responsible for committing genocide in Gaza and for failing to prevent and punish genocidal acts. South Africa contends that Israel has also violated other obligations under the Genocide Convention, including those concerning conspiracy to commit genocide, direct and public incitement to genocide, attempted genocide, and complicity in genocide. At the present stage of the proceedings, the Court is not required to ascertain whether any violations of Israel's obligations under the Genocide Convention have occurred. Such a finding could only be made by the Court at the stage of the examination of the merits of the present case. At the stage of making an order on the request for an indication of provisional measures, the Court's task is to establish whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. In the Court's view, at least some of the acts and omissions alleged by South Africa to have been committed by Israel in Gaza appear to be capable of falling within the provisions of the Convention. In light of the following, the Court concludes that, prima facie, it has jurisdiction pursuant to Article 9 of the Convention to entertain the case. Given this conclusion, the Court considers that it cannot accede to Israel's request that the case be removed from the general list. The Court turns next to the question of standing of South Africa. Court notes that the respondent did not challenge the standing of the applicant in the present proceedings. In the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia v. Myanmar, where Article 9 of the Genocide Convention was also invoked, the Court observed that all states parties to the Convention have a common interest to ensure the prevention, suppression, and punishment of genocide by committing themselves to fulfilling the obligations contained in the Convention. Such common interest implies that the obligations in question are owed by any state party to all the other state parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. The common interest in compliance with the relevant obligations under the Genocide Convention entails that any state party, without distinction, is entitled to invoke the responsibility of another state party for an alleged breach of its obligations erga omnes partes. Accordingly, the Court found that any state party to the Genocide Convention may invoke the responsibility of another state party, including through the institution of proceedings before the Court, with a view to determining the alleged failure to comply with its obligations erga omnes partes under the Convention and to bringing a failure to the end. The Court concludes prima facie that South Africa has standing to submit to it the dispute with Israel concerning alleged violations of obligations under the Genocide Convention. The Court then turns to the question of the rights whose protection is sought and the link between such rights and the measures requested. It recalls that its power to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At this stage of the proceedings, however, the Court is not called upon to determine definitively whether the rights which South Africa wishes to seek protected exist. It need only decide whether the rights claimed by South Africa and for which it seeks protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The Court recalls that in accordance with Article 1 of the Convention, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 2 provides that, I quote, "Genocide means any of the following acts committed with an intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the group. E. Forcibly transferring children of the group to another group. End of quote. Pursuant to Article 3 of the Genocide Convention, the following acts are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The provisions of the Convention are intended to protect the members of a national, ethnical, racial, or religious group from acts of genocide or any other punishable acts enumerated in Article 3. The Court considers that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party. As the Court has stated in other cases, in order for acts to fall within the scope of Article 2 of the Convention, the intent must be to destroy at least a substantial part of a particular group. This is demanded by the very nature of the crime of genocide, since the object and purpose of the Convention as a whole is to prevent the intentional destruction of groups. The part targeted must be significant enough to have an impact on the group as a whole. The Palestinians appear to constitute a distinct national, ethnical, racial, or religious group, and hence a protected group within the meaning of Article 2 of the Genocide Convention. The Court observes that, according to United Nations sources, the Palestinian population in the Gaza Strip comprises over 2 million people. Palestinians in the Gaza Strip form a substantial part of the protected group. The Court notes that the military operation being conducted by Israel following the attack of 7 October 2023 has resulted in a large number of deaths and injuries, as well as massive destruction of homes, the forcible displacement of the vast majority of the population, and extensive damage to civilian infrastructure. While figures relating to the Gaza Strip cannot be independently verified, recent information indicates that 25,700 Palestinians have been killed, over 63,000 injuries have been reported, over 360 housing units have been destroyed or partially damaged, and approximately 1.7 million persons have been internally displaced. The Court takes note in this regard of the statement by the United Nations Under-Secretary General for Humanitarian Affairs and Emergency Relief Coordinator, Mr. Martin Griffiths, on 5 January 2024. I quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under bombardment. Medical facilities are under relentless attack. A public health disaster is unfolding. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence while the world watches on." End of quote. Following a mission to North Gaza, the World Health Organization reported that as of 21 December 2023, I quote, "An unprecedented 93% of the population of Gaza is facing crisis levels of hunger, with insufficient food and high levels of malnutrition." End of quote. The Court further notes the statement issued by the Commissioner General of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, or UNRWA, Mr. Philippe Lazzarini, on 13 January 2024. I quote, "It's been 100 days since the devastating war started, killing and displacing people in Gaza following the horrific attacks that Hamas and other groups carried out against people in Israel. It's been 100 days of ordeal and anxiety for hostages and their families. In the past 100 days, sustained bombardment across the Gaza Strip caused the massive displacement of a population that is in a state of flux, constantly uprooted and forced to leave overnight, only to move to places which are just as unsafe. This war affected more than 2 million people, the entire population of Gaza. Many will carry lifelong scars, both physical and psychological. The vast majority, including children, are deeply traumatized. Overcrowded and unsanitary UNRWA shelters have become home to more than 1.4 million people. They lack everything, from food to hygiene to privacy. People live in inhumane conditions where diseases are spreading, including among children. They live through the unlivable with the clock ticking fast towards famine. The plight of children in Gaza is especially heartbreaking. An entire generation of children is traumatized and will take years to heal. Thousands have been killed, maimed, and orphaned. Hundreds of thousands are deprived of education. Their future is in jeopardy with far-reaching and long-lasting consequences. The UNRWA Commissioner General also stated that the crisis in Gaza is, I quote, compounded by dehumanizing language, end of quote. In this regard, the court has taken note of a number of statements made by senior Israeli officials. It calls attention in particular to the following examples. On 9 October 2023, Mr. Yoav Gallant, Defense Minister of Israel, announced that he had ordered a complete siege of Gaza City, and then that there would be no electricity, no food, no fuel, and that everything was closed. On the following day, Minister Gallant stated, speaking to Israeli troops on the Gaza border, I quote, "I have released all restraints. You saw what we are fighting against. We are fighting human animals. This is the ISIS of Gaza. This is what we are fighting against. Gaza won't return to what it was before. There will be no Hamas. We will eliminate everything. If it doesn't take one day, it will take a week. It will take weeks or even months. We will reach all places." End of quote. On 12 October 2023, Mr. Isaac Herzog, President of Israel, stated, referring to Gaza, I quote, "We are working, operating militarily according to rules of international law, unequivocally. It is an entire nation out there that is responsible. It is not true, this rhetoric about civilians not aware, not involved. It is absolutely not true. They could have risen up. They could have fought against that evil regime which took over Gaza in a coup d'etat. But we are at war. We are at war. We are at war. We are defending our homes. We are protecting our homes. That's the truth. And when a nation protects its home, it fights. And we will fight until we break their backbone." End of quote. On 13 October 2023, Mr. Israel Katz, then Minister of Energy and Infrastructure of Israel, stated on X, formerly Twitter, I quote, "We will fight the terrorist organization Hamas and destroy it. All the civilian population in Gaza is ordered to leave immediately. We will win. They will not receive a drop of water or a single battery until they leave the world." End of quote. The court also takes note of a press release of 16 November 2023 issued by 37 special rapporteurs, independent experts, and members of working groups part of the special procedures of the United Nations Human Rights Council, in which they voiced alarm over, I quote, "discernibly genocidal and dehumanizing rhetoric coming from senior Israeli government officials." End of quote. In addition, on 27 October 2023, the United Nations Committee on the Elimination of Racial Discrimination observed that it was highly concerned about the sharp increase in racist hate speech and dehumanization directed at Palestinians since 7 October. In the court's view, the aforementioned facts and circumstances are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. The Court then turns to the condition of the link between the plausible rights claimed by South Africa and the provisional measures requested. It considers that by their very nature, at least some of the provisional measures sought by South Africa are aimed at preserving the plausible rights it asserts on the basis of the Genocide Convention in the present case, namely, the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. Therefore, a link exists between the rights claimed by South Africa that the Court has found to be plausible and at least some of the provisional measures requested. The Court turns next to the question of risk of irreparable prejudice and urgency. It notes that, pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights might entail irreparable consequences. However, the power of the Court to indicate provisional measures will only be exercised if there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final decisions. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment, before the Court makes the final decision in the case. The Court must therefore consider whether such a risk exists at this stage of the proceedings. The Court is not called upon for purposes of its decision on the request for the indication of provisional measures to establish the existence of breaches of obligations under the Genocide Convention, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under that instrument. As already noted, the Court cannot at this stage make definitive findings of fact, and the right of each party to submit arguments with respect to the merits remains unaffected by the Court's decision on the request for the indication of provisional measures. The Court recalls that, as underlined in General Assembly Resolution 96-1 of 11 December 1946, I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End of quote. In view of the fundamental values sought to be protected by the Genocide Convention, the Court considers that the plausible rights in question in this proceeding, namely, the right of Palestinians in the Gaza Strip to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Genocide Convention, and the right of South Africa to seek Israel's compliance with the latter's obligation under the Convention, are of such a nature that prejudice to them is capable of causing irreparable harm. During the ongoing conflict, senior United Nations officials have repeatedly called attention to the risk of further deterioration of conditions in the Gaza Strip. The Court takes note, for instance, of the letter dated 6 December 2023, whereby the Secretary General of the United Nations brought the following information to the attention of the Security Council. I quote, "The healthcare system in Gaza is collapsing. Nowhere is safe in Gaza. Amid constant bombarding by the Israel Defense Forces and without shelter or the essentials to survive, I expect public order to completely break down soon due to the desperate conditions rendering even limited humanitarian assistance impossible. An even worse situation could unfold, including epidemic diseases and increased pressure for mass displacement into neighboring countries. We are facing a severe risk of collapse of the humanitarian system. The situation is fast deteriorating into a catastrophe with potentially irreversible implications for Palestinians as a whole and for peace and security in the region. Such an outcome must be avoided at all costs." End of quote. On 5 January 2024, the Secretary General wrote again to the Security Council, providing an update on the situation in the Gaza Strip and observing that, I quote, "Sadly, devastating levels of death and destruction continue," end of quote. The court also takes note of the 17 January 2024 statement issued by the UNRWA Commissioner General upon return from his 4th visit to the Gaza Strip since the beginning of the current conflict in Gaza. I quote, "Every time I visit Gaza, I witness how people have sunk further into despair, with the struggle for survival consuming every hour," end of quote. The court considers that the civilian population in the Gaza Strip remains extremely vulnerable. It recalls that the military operation conducted by Israel after 7 October 2023 has resulted inter alia in tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war, I quote, "will take many more long months," end of quote. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. The World Health Organization has estimated that 15% of the women giving birth in Gaza Strip are likely to experience complications, and indicates that maternal and newborn death rates are expected to increase due to the lack of access to medical care. In these circumstances, the court considers that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating further before the court renders its final judgment. The court recalls Israel's statement that it has taken certain steps to address and alleviate the conditions faced by the population in the Gaza Strip. The court further notes that the Attorney General of Israel recently stated that a call for intentional harm to civilians may amount to a criminal offense, including that of incitement, and that several such cases are being examined by Israeli law enforcement authorities. While such steps are to be encouraged, they are insufficient to remove the risk that irreparable prejudice will be caused before the court issues its final decision in the case. In light of the foregoing, the court considers that there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights found by the court to be plausible before it gives its final decision. The court concludes on the basis of the aforementioned considerations that the conditions required by its statute for it to indicate provisional measures are met. It is therefore necessary, pending its final decision, for the court to indicate certain measures in order to protect the rights claimed by South Africa that the court has found to be plausible. The court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by South Africa and the circumstances of the case, the court finds that the measures indicated need not be identical to those requested. The court considers that, with regard to the present situation, Israel must, in accordance with its obligations under the Genocide Convention, in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. The court recalls that these acts fall within the scope of Article 2 of the Convention when they are committed with the intent to destroy in whole or in part the group as such. The court further considers that Israel must ensure with immediate effect that its military forces do not commit any of the aforementioned acts. The Court is also of the view that Israel must take measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to the members of the Palestinian group in the Gaza Strip. The Court further considers that Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. Israel must also take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention against members of the Palestinian group in the Gaza Strip. Regarding the provisional measure requested by South Africa that Israel must submit a report to the Court on all measures taken to give effect to the order, the Court recalls that it has the power, reflected in Article 78 of the Rules of Court, to request the parties to provide information on any matter connected with the implementation of any provisional measures it has indicated. In view of the specific provisional measures it has decided to indicate, the Court considers that Israel must submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of this order. The report so provided shall then be communicated to South Africa, which shall be given the opportunity to submit to the Court its comments thereon. The Court recalls that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The Court reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions related to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of the Republic of South Africa and the State of Israel to submit arguments in respect of these questions. The order then states that the Court deems it necessary to emphasize that all parties to the conflict in the Gaza Strip are bound by international humanitarian law. It is gravely concerned about the fate of the hostages abducted during the attack in Israel on 7 October 2023 and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release. I shall now read out the operative part of the order. For these reasons, the Court indicates the following provisional measures. 1. By 15 votes to 2, the State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 15 votes to 2, the State of Israel shall ensure with immediate effect that its military does not commit any acts described in point 1 above. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Moseneke. Against, Judge Sebatinde, Judge Ad hoc Barak. By 16 votes to 1, The State of Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad Hoc, Barak, Moseneke. Against, Judge Sebutinde. By 16 votes to 1, the State of Israel shall take immediate and effective measures to ensure the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judges Ad Hoc, Barak, Moseneke. Against, Judge Sebutinde. By 15 votes to 2, the State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Convention on the Prevention and Punishment of the Crime of Genocide against members of the Palestinian group in the Gaza Strip. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Moseneke. Against, Judge Sebutinde, Judge Ad Hoc Barak. By 15 votes to 2, the State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 month as from the date of the order. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Youssef, Shway, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Moseneke. Against, Judge Sebutinde, Judge Ad Hoc Barak. I shall now call upon the Registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique les mesures conservatoires suivantes. 1. Par 15 voix contre 2, l'État d'Israël doit, conformément aux obligations lui incombant au titre de la Convention pour la prévention et la répression du crime de génocide, prendre toutes les mesures en son pouvoir pour prévenir la commission, à l'encontre des Palestiniens de Gaza, de tout acte entrant dans le champ d'application de l'article 2 de la Convention, en particulier les actes suivants. A. Meurtre de membres du groupe. B. Atteinte grave à l'intégrité physique ou mentale de membres du groupe. C. Soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle. Et D. Mesures visant à entraver les naissances au sein du groupe. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 2. Par 15 voix contre 2, l'État d'Israël doit veiller avec effet immédiat à ce que son armée ne commette aucun des actes visés au point 1 ci-dessus. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 3. Par 16 voix contre 1, l'État d'Israël doit prendre toutes les mesures en son pouvoir pour prévenir et punir l'incitation directe et publique à commettre le génocide à l'encontre des membres du groupe des Palestiniens de la bande de Gaza. Pour Madame Donoghue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka Abraham Benouna Youssouf, Madame Choué, Messieurs Bandari Robinson Salam Iwasawa Nolte, Madame Charlesworth, Monsieur Bran, juge, Messieurs Barak Moseneke, juge ad hoc, contre Madame Sebutinde, juge. 4. Par 16 voix contre une, l'État d'Israël doit prendre sans délai des mesures effectives pour permettre la fourniture des services de base et de l'aide humanitaire requis de toute urgence afin de remédier aux difficiles conditions d'existence auxquelles sont soumis les Palestiniens de la bande de Gaza. Pour Madame Donoyou, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Messieurs Barak, Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge. 5. Par 15 voix contre 2, l'État d'Israël doit prendre des mesures effectives pour prévenir la destruction et assurer la conservation des éléments de preuve relatifs aux allégations d'actes entrant dans le champ d'application des articles 2 et 3 de la Convention pour la prévention et la répression du crime de génocide que pour Madame Donoyou, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc, contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc. 6. Par 15 voix contre 2, l'État d'Israël doit soumettre à la Cour un rapport sur l'ensemble des mesures qu'il aura prises pour donner effet à la présente ordonnance dans un délai d'1 mois à compter de la date de celle-ci. Pour Madame Donoyou, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benouna, Youssouf, Madame Choué, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Moseneke, juge ad hoc. Contre, Madame Sebutinde, juge, Monsieur Barak, juge ad hoc.
Judge Choué appends a declaration to the order of the court. Judge Sebutinde appends a dissenting opinion to the order of the court. Judges Bandari and Nolte append declarations to the order of the court. Judge ad hoc Barak appends a separate opinion to the order of the court. The text of the court will be available from today in typescript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.
administration may well, given the way this has gone, be somewhat happy with this, but we'll have to see what comes out of Washington in the coming hours. And of course, it's not just the US. When you look at the international landscape, most of the international community is now believing in the idea that there should be an immediate ceasefire. Yes, there are some European countries.
Bring them home. Inshallah, give mushrooms. Inshallah, give mushrooms.
Hey, we have to.
Hello, everyone. How you doing? So, my name is Noy Leib, and this is Mayor Rappaport. We're a group of 5 soldiers who just got out of Gaza. We came specifically to the Hague because it's important for us not just to fight over there, but also to fight here with you. It's amazing.
Wanted.
Here you're standing and you're strong. And I'll be honest with you, I'll let Mayor speak in a second, but the war is not a fun thing. It's not an easy thing. We don't like going to war. You know, I'm a co-founder of a company. I'm 32 years old. It's not something that I want to do. But
there was still bombing going on the city of Tunis and the northern part. That one element that everybody waited for. People have been saying that for weeks now. There is ongoing systematic killing of all of people in Gaza. The UN warning of famine. We have a deputy general of the United Nations warned of systematic destruction of civic institutions and just systematic destruction of every means of life, turning Gaza into an uninhabitable place and forcing people into expulsion. People are waiting that this is continuing because of the mass bombing that has been relentless and very destructive and has turned Gaza into a nickel camp so far. That one line, despite all the positive rulings, because of this thing, because people are tired and exhausted, they want to go back to their homes, they want to see remaining family members, they want to go back to normal life. But the statement did not give them that, and that's why they're continuing to be restless.
Ceasefire!
No!
Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now!
Effectively, it's going to be well, yes, but it wasn't going to be that any which way. Israel wasn't going to abide by the ICJ ruling any which way, and it said that from the outset. So that's why, for me, although there's discussion to be had about the provisional measures and why the court embraced its own measures rather than those of South Africa, but for me, this is a court of justice. And the fact that they went for almost 36 minutes making the case, they basically made the case. Now, first of all, there is a dispute between South Africa and Israel that they accept that South Africa has a right to take this up to the ICJ. And second, and that's the most important for me, headline today, the ICJ has jurisdiction in the case of Gaza. That means it suspects there is genocide taking place in Gaza. It will take up the case. And the way the Judge Donahue, the head of the... Here is the circumstance. Here's what Israel has done. Here what Israel is doing. Here is what the various United Nations agencies heads have said. And the Secretary General. The WHO. And then Palestine will be free! Palestine will be free! Cats, and so on and so forth. So the basic rule that there is no evidence refrain from doing 1, 2, 3, 4, 5. Palestine! Free Palestine! Free Gaza! When they discuss this down the road and judge whether Israel is or is not genocide. 1, 2, 3, 4! 1, 2, 3, 4! 1, 2, 3, 4! Occupation now! Moving forward. Occupation now! Is a big word for South Africa. So they did not acquire the South African I don't know what goes in their minds, but I prefer that this guy be made my way and saying, you know, you said changes. They did go with Bosnia. Palestine will be free. Suggesting a whole number of things that Palestine will be free. Especially on the fact that Netanyahu, you will see. Palestine will be free. That they should allow for Palestine will be free. This is a way to show intelligence. I am saddened by the fact that there is no ceasefire. I am not saddened because I know Israel is not going to carry on with that ceasefire. We have to transition past the the United Nations has taken the case of genocide against Israel through its actions the past 3 years. That the principle of it, that it will take then it will put Israel on notice, and the amount of it, a number of things. What do you want? When do you want it? What do you want? Ceasefire! When do you want it? Now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Free Palestine! Free Palestine! Free Palestine! Free Palestine! And take some tough decisions. Free Palestine! Not only from their public opinion. See, because from the river to the sea! This case is about South Africa. Palestine will be free! Global South. Taking up a case where from the sea to the river, except in the West, Palestine will live forever. Genocide against the Palestinians. From the river to the sea. If the Western world is not going to take measures, Palestine will be free. Today, themselves, driven by moral consideration as much as by narcissistic. Palestine will live forever. Free Palestine! Free Gaza! Free Palestine! Free Gaza! Stop the genocide! Stop the genocide! Stop the genocide! Stop the genocide! Gaza, don't you cry! Okay. Palestine will never die! For what is it? Gaza, don't you cry! Palestine will never die! Okay, a bit, yeah. Free Palestine! Free Palestine! From the river to the sea! Free Palestine! Free
What is your reaction to what happened to the decision today? Was it something you were waiting or that did it make you angry?
I honestly did not expect it. I honestly did not expect it because I know how Israel stands in front of Europe and the West. So I did not expect it at all, but I'm very happy with the result. And I don't think there's any denial anymore for the fact that it's a genocide that's happening. 25,000 people already died. They're under inhuman conditions. There's no denying that, and I think that the whole world saw it right now. I do think it's very urgent, and I'm very angry, of course, that it still has not happened since October, and that it came to this. 25,000 deaths and more than 50,000 injuries. I don't think we had to have a long time between this, and I think it should stop right now. Ceasefire, like you're hearing. Ceasefire right now. Give Palestinians the right that they deserve, their human rights. They deserve food, water, fuel. They deserve everything like we all do, and I think it should stop right now. Oh, okay. It's okay. No, it's okay. But is the camera not working or is the microphone not working? Oh, it's working now. I am very happy about what I heard. I think it's a step forward for a ceasefire that we're all demanding right now. I think by step we'll come where we want to be. Even though it's already too late, in my opinion. There are already 25,000 deaths and 60,000 injured people, and it is not stopping. It's continuing every day. So, yeah, I think it's very important.
But at least like a ceasefire could have been like what you did.
Yeah,
make you upset or somehow?
Of course it makes me upset that there's still no ceasefire now, but I think it's a step forward. And I really hope that a ceasefire will be there as soon as possible.
Palestine will never die.
Palestine will never die. 1, 2, 3, 4. 1, 2, 3, 4. Occupation no more. Occupation no more.
قيمة لها تكثيف
5, 6, 7, 8. Israel is terror state. Israel is terror state. Israel is terror state. Israel is terror state. 1, 2, 3, 4. 1, 2, 3, 4. Occupation no more. Occupation no more. 5, 6, 7, 8.
You know which channel it is?
USA! How many kids did you kill today? Israel! USA! How many kids did you kill today?
Associated Press.
From the river to the sea! Palestine will be free! From the river will be free! From the sea to the river! From the sea to the river! Palestine will live forever! Free, free Palestine! Free, free Palestine! Free, free Palestine!
Netanyahu, you can hide!
Netanyahu, you can hide!
You are part of genocide!
You are part of genocide!
Israel, USA, how many kids did you kill today?
Israel, USA, how many kids did you kill today?
Free, free Palestine!
Free, free Palestine! Free, free Palestine! Free, free Palestine!
1, 2, 3, 4!
1, 2, 3, 4! Occupation no more! Occupation no more! 5, 6, 7, 8! 5, 6, 7, 8! Israel is terror state! Israel is terror state!
Israel is a terror state!
Israel is terror state!
Israel is a terror state!
Israel! Stop the genocide!
when exactly, but the
Viva, viva Palestina!
See you again. We're waiting to hear the exact time at which they will come out of the court to give a speech to you. Until that time, we are going to stay here. Today we heard some good, but no fucking ceasefire, so please make yourself very, very loud. What do we want? Ceasefire! When do we want it? Now! What do we want? Ceasefire! When do we want it? Now! What do we want? Ceasefire! Now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now!
Oh, yeah.
Yes.
Ah, yes.
Oh, this is so
Oh, what's happening? I've found a way to get out of here. Yeah.
Just come out of court, you know. Do you want me to give you a minute? Are you alright?
Yes, you are right.
Okay. So we have Minister of International Relations and Cooperation of South Africa, Dr. Lady Panda, who's going to speak to you. Director General of the Foreign Ministry at home, Mr. Zain Dango. Yeah, I'm sure you know him. So the minister is going to speak, and then Omar is going to speak as well. DG will take questions. You all ready?
Yes.
Over to you.
My name is Naledi Pandor, and I'm the South African Minister of International Relations and Cooperation. I wish to begin by thanking the judges of the International Court of Justice for dealing with this matter expeditiously. Given the urgency of the need to protect innocent civilians in Palestine and to ensure that the harm that South Africa has referred to in the case it brought before the ICJ, that harm is addressed and that people's lives are saved. The saving of life is not merely with respect to having a ceasefire, it's to ensuring that humanitarian aid is provided to those who need support, as well as ensuring that the State of Israel, which is currently the occupier and administrator in Palestine, provides the necessary basic services that the residents of Gaza and the West Bank require. This case was very much about international bodies ensuring that they exercise their responsibility to protect us all as global citizens. All member states of the United Nations have attached their signatures to a range of instruments, but when lives are threatened, these instruments are not brought to bear. And South Africa had the view that we could not stand idly by and continue to observe the killing of thousands of Palestinian citizens who had no role in the awful act of hostage-taking and killing that was done by Hamas. And therefore we thought it important that we do report and apply to the International Court of Justice that the measures provided within the Convention for the Punishment and Prevention of Genocide are brought to bear, and that the State of Israel is called upon by the judges to act to protect civilians and to end the massive level of harm that we have seen since the Israeli action began, and we agree entirely with the judges that Hamas should release the hostages that they're currently holding. We also, in our various engagements with our partners internationally, believe the moment is now ripe for there to be negotiations for a two-state solution to end this conflict decisively.
Minister, are you disappointed there wasn't a ceasefire? Are you disappointed the court didn't call for a
I
ceasefire?
believe that in exercising the order, there would have to be a ceasefire. Without it, the order doesn't actually work. I would have wanted a ceasefire.
They didn't specifically call
No,
it a
they
ceasefire.
didn't.
Are you disappointed
But how-
that they didn't specify that in their
I
provisions?
have no way that I'm going to say I'm disappointed. I hoped for it, but the fact of delivering humanitarian aid, the fact of taking measures that reduce the levels of harm against persons who have no role in what Israel is combating, for me requires a ceasefire, and I believe Israel would have to attend to how it conducts its search for the hostages and for those Hamas individuals who carried out the October 7 attack.
What's the next step?
I believe that the court judgment needs to be read very, very carefully. They've given very, very direct instructions. We are satisfied that the provisional measures that we sought to be addressed would be addressed by the court. And I believe if you read the convention very carefully, the matter of how a war or conflict is conducted is not elaborated. I would have wanted that the word cessation is included in the judgment, but I am satisfied with the directives that have been given, and in particular I was concerned as the president of the court was reading the order that reference wasn't being made to a report, because the reporting is absolutely imperative. The monitoring of action in terms of the order is vital, and so for the fact that a monthly report, a report within 1 month of this date, has been ordered is, I believe, very significant.
What does it say to Germany and the United States who have called this case meritless?
Well, the fact that the court says, remember that today we're not deciding about the allegation of genocide. What we're dealing with are the provisional measures. It's clear that the court does say circumstances exist where it is plausible that genocidal acts have been committed. This, of course, means once the merit case is addressed, and if the finding is that there has been genocide, those states that have aided and abetted become a party to commission of an infringement in terms of the convention.
Do you think Israel will conform to the orders laid down by the court today?
I've never really been hopeful about Israel, but Israel has very powerful friends who I hope will advise Israel that they should act
Minister, what does
in
it say
terms
about
of the
Israel?
order.
Would you say? What does it say about Israel as a country and a government and a military?
I think that's for you and the public to decide. What we've said is, here's an international instrument, let us bring it into operation, and let's stop being observers of significant harm. Let's act, and South Africa has acted. And what the court has actually indicated is that this convention is being brought to life in a very practical way. And I now think what we want is that the member states of the United Nations must oversee the process and ensure that we create a basis for a global community in which a resort to arms is no longer easy. A resort to abuse is no longer easy, and that more effort is now directed toward negotiation and toward seeking peaceful means of ending conflict.
And do you think Hamas
relations with Israel?
Well, as far as I understand the convention, States are members, states are signatories, and you bring actions with reference to states, not to particular groups.
But has Hamas behaved genocidally?
Well, I believe that what has been done by Hamas is certainly caused great harm, and I do think that the hostages should be freed, and that's what we must focus on.
Madam Minister, do you believe that the decision of the court will help, let's say, in solving the problem of the Israeli aggression against the Palestinians today, and in the short term maybe can help finding a political solution to the conflict between the Palestinian people and the Israeli occupation?
Well, my hope is that we will begin to move toward a process where substantively a two-state solution is being discussed. The people of Palestine have suffered harm for many, many decades. I don't believe it will end today or tomorrow. But what we've done is a very clear signal has been sent by the court. And it's now a test for the government and people of Israel as to whether they will act in a manner that says all of us must respect international law.
Could you tell me
the implications for international law?
Hello. Well, if Israel acts in accord with it, I think the implications are for a future hopeful world. Should it not, then essentially we're opening up room for all abusers in many conflicts throughout the world, and I think we'll be setting a terrible precedent. So what all of us should do is call on Israel to act in terms of the decision.
But will you sever ties with Israel, or are you preserving ties with Israel?
I don't think it's a matter of South Africa and Israel here. The real issue, all your questions are about Israel, but the real issue is the people of Palestine who are being killed every day. The people of Palestine who are sleeping in the cold. The people of Palestine who are denied food, water and energy. That is the critical issue that all of us should focus upon.
And on that note, we're going to ask the Vice Foreign Minister
with the people of Palestine, we stand with the people of Palestine, and our message to them is never give up hope. South Africa got over the apartheid oppression. They will overcome.
And for that we'll ever be grateful, Your Excellency.
Thank you.
Allow me to start by saying that we concur with everything that Her Excellency, the Minister of International Cooperation of South Africa, Naledi Pandor, has stated in front of all of you, and to read a message from the Palestinian people on this very important day. This is a historic day. Palestine welcomes the momentous order by the International Court of Justice. This order means that the court recognized the gravity of the situation and was convinced by South Africa's compelling presentation that was based on law and fact that there are plausible cause to believe that Israel is committing genocide in Gaza. It means that the cries and suffering of our people in Gaza have been heard in the great hall of justice. Israel failed. It failed to convince the court to dismiss the complaint to prove that it is not deliberately violating Genocide Convention. The ICJ judges assessed the facts and the law and issued their order. Israel now will stand trial accused of committing the crime of all crimes. We call on states to ensure that all provisional measures ordered by the court are implemented. States and governments have clear obligations in light of this order. First and foremost, they must make sure they are not complicit in this genocide. This is a good day for humanity. This ruling is in favor of international system based on law and against exceptionalism and double standards. It should be a wake-up call for Israel and its enablers. The State of Palestine will undertake every endeavor to follow up on this important ruling by the courts towards ensuring the rights of the Palestinian people and ensuring justice. To this end, and with deep conviction in the rule of law, we will continue pursuing accountability and justice in all forms, including in a few weeks' time when we return here to the ICJ on the 19th of February for the oral hearings in the advisory opinion proceedings on Israel's illegal occupation and regime inside the occupied Palestinian territory. This illegal occupation and apartheid regime must be brought to an end. Palestine will forever be grateful to South Africa for taking this bold step of active solidarity. Together with peace-loving nations, we will continue to work to stop genocide, hold perpetrators to account, and work to stop all other atrocities against our people. Just few words in Arabic and I'll conclude my statement and open the way for questions and answers. هذا يوم تاريخي لفلسطين والإنسانية جمعاء. ترحب فلسطين بقرار محكمة العدل الدولية الحاسم فيما يخص الإجراءات الاحترازية الواجبة بخصوص الشكوى المقدمة من جمهورية جنوب أفريقيا حول الإبادة الجماعية التي تشنها إسرائيل على الشعب الفلسطيني في قطاع غزة. هذا يعني أن إسرائيل ستحاكم في قادم الأيام بتهمة الإبادة الجماعية وانتهاكات أخرى لمعاهدة الإبادة الجماعية في أعلى سلطة قضائية في العالم. لقد فشلت إسرائيل في التهرب من المساءلة، فشلت في تبرير ما ترتكبه من فظائع. قضاة محكمة العدل الدولية قيموا ما قدم لهم من حقائق ووقائع ومعطيات قانونية من قبل جنوب أفريقيا، ولم يتأثروا بمحاولة دولة الاحتلال لتسييس ما قدمته أو تحريف أو أكاذيب. هذا الحكم هو انتصار للقانون الدولي والإنسانية ورفض واضح للفوضى والمعايير المزدوجة. هذه رسالة واضحة لدولة الاحتلال وداعميها بأن لا أحد فوق القانون أو خارج نطاق المساءلة. لقد ولت أيام الإفلات من العقاب. في هذا السياق ندعو جميع الدول إلى ضمان تطبيق الحكم الصادر من المحكمة اليوم والالتزام بمسؤولياتهم بمقتضى هذا الحكم، وتحديدا بأن لا يساعدوا حكومة الاحتلال بارتكاب مزيد من الجرائم وأن لا يتورطوا أو يتواطؤوا في ارتكاب هذه الجرائم، وتحديدا مسألة تزويد إسرائيل بالسلاح. أختتم بتأكيد امتنان القيادة الفلسطينية والشعب الفلسطيني لشعب وحكومة جنوب أفريقيا لاتخاذ هذه الخطوة الجريئة من التضامن العملي، وسنواصل جنبا إلى جنب مع الدول الأخرى صاحبة المبادئ والشعوب العمل على وقف الإبادة الجماعية ومحاسبة إسرائيل على فظائعها ضد الشعب الفلسطيني والدفاع عن حقوقنا الجماعية كشعوب العالم في المساواة في حقوق الإنسان. هذه معركة علينا أن ننتصر فيها من أجل الحرية والإنسانية. شكرا.
Sir, can you tell us what the implications of this ruling are for Israel's allies, especially the US and the UK?
The implications are that they have direct responsibilities as of now not to be complicit in any of the crimes that Israel is committing in the Gaza Strip, not to provide any assistance to these crimes, and to hold Israel to account while it makes these crimes.
So do you believe that South African minister said if Israel was to comply with the ruling, it in effect, even though it wasn't specified, it means they have to have a...
The order cannot be implemented in any way, shape or form.
How do you transport humanitarian aid without a ceasefire?
Exactly.
How would you provide water, access to energy? How do you ensure that those who are injured have health care and so on? Without a ceasefire, none of these things can be done. So if you read the order by implication, a ceasefire must happen.
Yes. The order cannot be implemented in any way, shape or form without a ceasefire. It's as simple as that. I think in each and every aspect of the order there is a call for a ceasefire.
And President Biden is going to get that message?
Well, I'm not President Biden, so I can't answer for him. I think you'll have to ask him. But I'm sure, as a humanitarian, he would support any action that seeks to save the lives of others.
And it is a duty for all countries to implement. They have an obligation under the Genocide Convention. They cannot escape that.
معالي السفير، ألا تخشى مثلا أن المحكمة لم تعلن مباشرة وقف إطلاق النار؟ أليست خيبة أمل بالنسبة لكم؟
على الإطلاق، كل ما في الأمر هو يدعو إلى وقف إطلاق النار. لا يمكن تنفيذ أمر المحكمة اليوم من دون وقف إطلاق النار، ويجب على إسرائيل أن تبرر نفسها خلال شهر من الآن لماذا لم ينفذ أمر المحكمة. ودون وقف إطلاق النار لا يمكن أن ينفذ أمر المحكمة، لا يمكن إيصال المساعدات الإنسانية، لا يمكن تقليل ومنع الخسائر بين المدنيين، لا يمكن وقف الدمار وما ترتكبه، وكل ذلك كان في أمر المحكمة. لذلك وقف إطلاق النار هو عنصر رئيسي في كل جزء من قرار المحكمة.
Thank you very much. I'm from Tunisia. I'm truly honored Nelson Mandela honored your country. Thank you very much, madam. Thank you very much.